Good day to you, and welcome to Paddocks Club. Today we're going to talk about smoking in sectional title schemes. It's an old problem. An overview of what I'll be dealing with. Firstly, an example of the problem, then we'll look at the Tobacco Products Control Act. What does the law provide? Can action be taken to stop smoking? And who can and must take that action? An example of the problem was given by Sean Smith on the discussion forum. Ongoing smoke was coming from a lower section, coming out of the section and then drifting into the windows of an upstairs section. The people upstairs first complained, then they started to fight back. They banged on the floor and they interfered with the water supply and generally caused trouble. The trustees wrote to both sets of occupiers telling them that they were in breach of Section 44 of the Act and that they must stop these actions. The trustees were not prepared to take it further, and they told the parties that prescribed Management Rule 71 arbitration was available to them, and if they wanted to deal with the matter further, that's how they should do so. The hire owner's lawyer wrote to the trustees. In essence, I've given you the text, but what this says is, look, there's a national act called the Tobacco Products Control Act. It applies in your scheme. You have to enforce it, and if you don't, you personally, as trustees, could be liable. Well, that the managing agent, Sean in this case, found completely unreasonable. That the trustees should be asked to enforce all the laws, and he's quite right. This is simply wrong. It's wrong in a number of ways, apart from being phrased in very archaic and language and using a whole lot of capitalized cliche phrases. It is designed, quite obviously designed, purely to frighten. But you're only frightened if you don't know what's really going on. So let's look at the Tobacco Products Control Act. This doesn't, in fact, apply to sectional title schemes at all in the normal sense. It deals with public places and provides special arrangements so that people who don't smoke won't necessarily have to put up with people who do smoke. So smoking is a permitted activity in South Africa, at least the smoking of tobacco, and it's specifically permitted in terms of this Act in various places, subject to various restrictions. Now, smoking is not allowed, whether it's a public or a private place, in a car where any child under 12 years old is present in that car, or in any private place used for commercial childcare, schooling or tutoring. So the reach of the Act does go into private places, but only to protect children in those two particular instances. So by and large, it simply won't apply in the context of a sectional title scheme at all, because as you know, all the sections are individually owned, all the common property is owned by this limited group of people. They're simply not public places. So what does the law actually provide in these circumstances? Well, Section 44 of the Act in subsections 1, D and E, and I've highlighted the important bits. An owner is obliged to use and enjoy the common property so as not to unreasonably to interfere with the use and enjoyment thereof by other owners or other persons lawfully on the premises. And secondly, must not use a section or exclusive use area or permit it to be used in such a way that it causes a nuisance to any other occupier of a section. So owners and occupiers have rights and duties in this regard. A duty not to cause a nuisance and a right not to be unreasonably disturbed. Cigarette smoke is, of course, only one of a number of possible causes of nuisance that can arise in a sectional title scheme. You get noxious fumes. Sometimes you might have people making things or cooking. There's dust, noise, vibration, sewage, odors, even light in certain instances will be considered to be a nuisance. But there is no statutory definition of nuisance or unreasonable interference. There can't be. It's a wide concept that applies depending on the circumstances. Therefore, the common law applies. Private nuisance is an unlawful and an unreasonable interference with an occupier's use and enjoyment of their rights in land. The unreasonable interference depends on the circumstances of each case, but the inconvenience must cause a material interference with the way in which an ordinary person would use the land. It mustn't be calculated on the basis of any particular sensitive standards. On this basis, the situation must result in a substantial degree of interference for the ordinary user in order to qualify as a nuisance. And people are expected to have a reasonable ability to withstand adverse conditions, to display some robustness, the ability to give and take some inconvenience, especially when they're in premises designed for high-density living. Nuisance doesn't necessarily arise because the complainant is abnormally sensitive. So what, in a nutshell, is the test? Is the amount, nature or character of the tobacco smoke coming from the lower apartment such that it would significantly affect the ability of the average person to use the upper apartment? If so, it's an actionable nuisance. If not, then it is not. An unusual aversion to smoking or medical condition is not relevant in the test as to whether or not it is a nuisance. So, if it is a nuisance, who can and must take legal action? The body corporate must only act if this is a breach of one or more of the scheme's rules. The fact is the smoking is taking place in a section and it's disturbing somebody else in another section. The common property is not really involved. It's not the duty of the body corporate to enforce the provisions of the Act or any other law that doesn't relate to the common property or the buildings in the scheme. Any affected party may, of course, go to the court or to arbitration in terms of Prescribed Management Rule 72. And if an affected party says, please, will you enforce this, trustees, but they refuse to do so themselves, then one must ask the question is just how badly are they in fact being inconvenienced if they're not prepared to take action themselves. Thank you very much for watching this Paddocks Club tutorial. I look forward to chatting to you in the discussion forum.